but for your final exam and also test, the question will be in the form of a direct question or in the mode of what we call, okay, this one is a short scenario case or problematic question. Have we discussed this one or not?
Not
Did we
yet.
discuss? Not yet. Okay, so for this one, okay, for this type of question, we called it as a direct question. Means that when you read the question, then you know that you know, what is the question all about. Okay? Maksudnya sekali baca tu kita dah dapat idea. Okay? Apa yang soalan perlukan? What is the question needed? Okay, for you to answer. So for example, for this question, okay, distinguish the following. Means that you have to differentiate between public law and private law. Okay, what is public law? What is private law? So just refer to your notes and also my explanation and also from your reading. Then you just answer. Okay, put the notes there, and also as well as for the question of contract and tort. You distinguish between contract and tort. So just have to identify, okay, what is the difference, okay, between contract and tort. So this question kita panggil dia soalan direct question. Okay, meanwhile for this type of question, okay, you don't have to answer this one. I just want to show you the type of question. Okay, normally in my class, okay, after every topic, I will show you one question, one previous exam question or test question regarding to that topic. So we try to attempt that question in order for all of you to familiarize with the type of legal question and how to answer it. Okay, normally for legal question, okay, we apply IRAC. Okay, we apply IRAC. Okay, I put it in the chat. Okay, IRAC. So, okay, we use IRAC. Okay, this principle. Okay, to answer law question. I refer to identify. Okay, identify the issues. Okay, what is the issues? You have to extract out what is the issue from the question first. Okay, bila baca soalan, when you read the question, you have to read word by word and line by line in order for you to understand and also figure out what is the issue that arise in that question. Then you have to apply the relevant rule. R refer to rule. Okay, I refer to issues. Okay, you have to identify the issues. R refer to rule. Okay, so what kind of rule that you have to apply for this type of question? Okay, this one is for short scenario or problematic or case study question. And then you apply the rule. Okay, once you identify the issue and you have identified the correct rule to apply, okay, then you have to elaborate. Okay, apply and elaborate. Okay, how the rule can apply to solve the issue. And last C is conclude. Conclude means that you have to give a decision, because we know that for legal question, okay, for legal question means that you will have an opportunity to be a lawyer and also a judge. Okay, you will decide, okay, what is the judgment, what is the decision of that case. Okay, but okay, as far as we're concerned that in a legal question, okay, we know that in order to answer the legal question, you have to insert a relevant section, you have to insert relevant article, for example, and also you have to insert relevant rule or relevant principle in order to answer the question, as well as kalau kata ada cases. Okay, so you also have to put the case there, not just the name of the case, but also with the fact of the case. Kena masukkan fakta case lengkap. So, okay, for example, in this question, okay, when we look at the question right now in front of you, okay, take 1 minute, you have your time, look at the question. So, please identify, okay, what is the issue? Okay, what is the issue in this case, and what kind of rule that we can apply in order to solve the problem happened to Muhammad, and what is the decision? Okay, your attendance in e-learning. So please sign in your attendance in e-learning. In the meantime, read the short scenario question in front of you right now. Okay, class. So for this question, what is the issue? Apa isunya? Dah habis baca? Have you finished read the question or not yet? So what is the issue in this case? 1D, enter your premise, and as he stepped inside, he slipped and fell as the floor at the branch entrance was very wet and slippery. There were no warning signs cautioning that the floor was slippery or wet. Muhammad was hurt very badly and was hospitalized for 1 month. If Muhammad decides to take legal action, will the legal action be based on contract or tort? Give reason for your answer. Okay, referring to what we already learned and we already discussed in this class. Okay, so right now we want to decide, okay, the case of Muhammad. So sekarang kita nak figure out, okay, what is the issue? We want to figure out what is the issue in this case. Class.
Muhammad was hurt. I mean, because he slipped. Because due to the slippery floor of the place.
Okay, I think I said that Muhammad was hurt due to slippery floor. Okay, so the issue is right now Muhammad want to take action. Okay, Muhammad want to take action against the management of the premise. Okay, so the action must be based on what? Okay, the question bawah tu. Muhammad want to take action, okay, on what happened to him. Okay, bila mana dalam kes ini Muhammad was hurt due to the when he entered that premise, okay, he was hurt due to the slippery floor. So you want to take action. The question right now is, okay, you want to take legal action based on what law?
The law of tort.
Yeah, or tort. Okay, so he can take action, okay, against the management of premise based on tort. So far as okay, we already discussed about law of tort. Under law of tort, there are several branches of law. So which law? Okay, if you still remember our discussion on law of tort.
Assault and battery.
Yes, Esther?
Is it assault and battery?
Assault and battery. Okay, ada orang lain lagi? Cuba nak jawab. Esther jawab assault and battery. Okay, go, you cakap, go cakap negligence. Okay, so in this case, okay, it is clear that shows that negligence, okay, negligence on part of the management of the premise. Okay, bila mana kita nampak kat sini failure, okay, in providing warning signs. Okay, no warning signs cautioning that the floor was slippery or wet. So fail in provide warning signs, proper warning signs. Therefore, at the end of the day, okay, Muhammad was hurt. Okay. Jadi kat dalam kes ini jelas menunjukkan berlakunya kecuaian. Kecuaian dalam menyediakan sign amaran, tanda amaran yang sepatutnya, yang sewajarnya untuk mengelakkan orang yang datang ke premis tersebut mengalami kecederaan. So Muhammad can be visitor. Okay, Muhammad maybe also invitees, orang yang diundang, okay, kepada untuk masuki premis tersebut. So we know that in the concept of negligence, okay, tanggungjawab, duty of care of someone is to all, bukannya kepada certain people saja. Jadi kalau kata employer, tanggungjawab dia, okay, duty of care of employer bukan saja, not just for his or her employees, but also for other people. Okay, means that it also include invitees, licensees, orang yang mempunyai kebenaran untuk masuki, orang yang diundang, and also visitors, okay, pelawat yang datang, but not for trespasser lah. Yeah, but not for trespasser. So dalam, if you still remember, okay, during our discussion on negligence, there are 3 requirements. And I think I already highlight about the 3 requirements of negligence. Untuk Muhammad, okay, menggunakan negligence, okay, to take charge, okay, to take charge against the management of the premise. Muhammad has to satisfy 3 requirement of negligence. First, duty of care. So we know that the management of the premise have duty of care, okay, towards all people who enter that premise. And then second, breach of duty of care happened there. So which part yang menunjukkan berlakunya pelanggaran tanggungjawab berhati-hati? There's which part of the case shows that breach of duty of care on the part of management of the premise? Kat mana dalam cerita ni?
The no warning signs.
Okay, there were no warning signs. So kita katakan berlakunya pelanggaran tanggungjawab berhati-hati. Okay, kegagalan menyediakan tanda amaran yang sesuai. And then yang ketiga, okay, the third requirement of negligence is damages. Okay, damages occur to someone. Kerugian berlaku kepada seseorang. So in this case, kerugian berlaku kepada Muhammad. Okay, mana Muhammad was hurt very badly and was hospitalized for 1 month. Okay, so all the expenses of medical expenses, okay, bear by Muhammad should be a burden, okay, for management of the premise. Okay, disebabkan oleh kecuaian mereka, maka Muhammad mengalami kecederaan. So in this case, we can say that the 3 requirements of negligence been satisfied by Muhammad, and Muhammad can take action of negligence against the management of premise. Okay. Tapi manakah kita tak belajar, we will not discuss in detail about the case of negligence. Okay, in fact, sebabnya negligence, a lot of thought is just part of the discussion under Malaysian legal system. We are not go in detail. Bukannya kita perlu belajar berkenaan dengan kes apa yang ada dalam negligence tu lah. Okay, so kalau kata ada negligence case yang you belajar, then you can insert it. But I think for MOT student, management of technology students, you don't have to go in thorough about law of tort. You just have to know that under law of tort, there are several branches of law, just enough. Okay, you don't have to know what is the decided case in every types of branches of law of tort. Tapi once you come to the discussion of law of contract later, you will learn lots of cases. Okay. Cuma kena pastikanlah once you answer final exam or test, okay, you have to support your argument using decided cases or relevant cases which has been decided by judge. Bukannya kes yang tiba-tiba muncul pada hari tersebut tu tak nak. Kita nak kes yang memang kita belajar dan memang ada decision dia lah. Tak boleh lah nak pakai kes yang you reka sendiri, tiba-tiba baru je ada kes pada hari tersebut bila masa jawab soalan, and then later on you got an idea kes Ali versus Abu. And then keluarlah fakta yang baru yang kita tak pernah jumpa. So that one will not be recognized as a true answer, okay, for that question lah. bila nak jawab soalan nanti, you have to support your argument with decided cases. Bukan kes yang tiba-tiba muncul. So this one is just give you a view, okay, how to answer legal question. Yeah. Nanti bila kita dah belajar law of contract later, okay, when we learn part of law of contract later, I will show you several past year exam question that we try to attempt, okay, and it then that question must have that question when you have to answer that question, you have to insert section as well as cases. Yeah. So for this part, it just want you to know that for legal question, we have two modes of question, direct question and also problematic question or short scenario is. Okay, so right now we go to the sources of Malaysian law. Okay, since we already discussed about definition of law, function of law, types of offences, and also classification of law. Okay, so right now we come to the sources of Malaysian law. So class, what appear in front of you right now is two types of sources of law, i.e. written and also unwritten. You can see from your slides again. Under the written, we have federal and state constitution and also legislation. Either it's enacted by parliament or state assemblies, okay, where act will be passed by parliament and enactments or ordinance can be passed by state assemblies. State assemblies will not pass act. State assemblies will not enact any act. So act only exclusively for parliament. Okay, akta hanya boleh diluluskan oleh parlimen. Under parlimen, we have two House of Lords, i.e. Dewan Negara and also Dewan Rakyat. Ada dua dewan dalam tu. And then under the written law also, we have subsidiary legislation. Okay, beside that, beside the written law, we have unwritten law. Under the unwritten law, we have English law, undang-undang English, and we already learned a little bit on what is English law, i.e. law of tort. Later on, you will learn about the common law, statute, equity, and so on. And under the unwritten law also, we have judicial decision. Judicial decision refer to judgment of a judge. Judgment of a judge in deciding a case. All the decision by judge will be compiled. It will be compiled and put it in a, we name it as a journal. Okay, jadi bila mana selesai suatu kes tersebut akan dimasukkan ke dalam journal. So journal ni a compilation of case. So in Malaysia we have two types of journal. Okay, iaitu current law journal, CLJ, we know it as CLJ or MLJ, Malayan Law Journal. Okay, if you want to Google any case, okay, you know the name of the case. For example, case you want to know the case of Anwar Ibrahim, for example, and you want to know what is the fact of the case, who is the judge sitting in that case, who is the prosecutor, pendakwa raya siapa, you want to know who is the defense counsel, and what is the decision of judge, what is the rule applied in that case. You want to know the real, okay, the real wording okay, used in that case. Okay, you can Google, okay, the case through the LexisNexis. LexisNexis is a website. Okay, it's a website which cited all the decided cases as well as reported cases which have been decided from the High Court, Court of Appeal and also Federal Court. Semua kes-kes yang diputuskan dalam website ni LexisNexis. And for this website, we have to subscribe, in fact, but you can also, okay, since you tak subscribe, okay, this web, you can access through PSZ, okay, PSZ, Pustaka Sultanah Zanariah website. Okay, so you just go to the link of LexisNexis, and then you can Google, okay, whatever case. But right now, some of the cases also can be easily Googled through the Google Scholar web. Google Scholar web. You may also ask Mr. Google, okay, to search for you, but the fact sometimes in Mr. Google not fully fact as reported in the CLJ or MLJ. That one is for the case decided by judge. So judicial decision, if you refer to Malay book, you akan jumpa perkataan ini, duluan kehakiman. Duluan kehakiman means that whatever has been decided, okay, by the judge, can refer to one case, then that one is considered as duluan kehakiman, the decision by a judge. Customs, customs refer to adat lah, okay, custom, adat. So after finish the discussion on judicial decision, we will discuss on custom, and there are two prominent custom in Malaysia, i.e. adat Perpati and also adat Temenggung. So we'll discuss on that, and Islamic law. Islamic law is also considered as unwritten law. From this slide, okay, from this slide, you can see that there are two sources of law, iaitu undang-undang bertulis and also undang-undang tak bertulis. Tapi apa yang nampak jelas, okay, what is the clear from these two division of sources of law? Apa yang membezakan di antara written and unwritten? Adakah for unwritten law, for English law, judicial decision, kita tak jumpa bahan bertulis yang untuk kita rujuk sebab nama dia undang-undang tak bertulis. Okay. Kalau tak jumpa penulisan for judicial decision, macam mana kita nak lihat keputusan hakim yang lepas? Okay, so CLJ, MLJ itu tak dikira sebagai benda bertulis ke? Adakah disebabkan itu dinamakan unwritten, undang-undang tak bertulis? Yeah. And for Islamic law, we know that for Islamic law, we refer to our basis for Islamic law, our foundation of Islamic law, we refer to Quran, Hadith, Ijma' ulama, and then several concepts under the Islamic maqasid to give a decision, okay, for a case which relates to Syariah law. Sedangkan semua tu mesti ada bahan bertulis yang kita boleh rujuk. Okay, so why untuk division, okay, untuk dipecahkan sources of law ni, sumber undang-undang ni dipecahkan kepada undang-undang bertulis dan undang-undang tidak bertulis. Kalau you nampak daripada slide ni, apa yang membezakan sebenarnya? Anyone like to try? Esther would like to try? Why we name it as unwritten for English law, judicial decision, custom, and also for Islamic law?
Is it because written law is enacted under the parliament and unwritten law is not under the parliament?
Yes, that's correct. Okay. Yang membezakan, bukan yang kita katakan kita letakkan ini sebagai written dan okay, unwritten, bertulis dan tak bertulis tu, yang memandangkan yang tak bertulis tu bukan yang tak ada sumber yang kita boleh rujuk. Ada sumber yang kita boleh rujuk, ada bahan dia, ada buku, ada kitab yang kita boleh rujuk. Tapi, okay, dinamakan sebagai written, okay, for law being passed by parliament and also state assemblies because it's enacted by, by our government. Okay, enacted by our government. Itu yang membezakan So all of these, okay, dan satu lagi yang membezakan, okay, what the main difference, okay, between a written and unwritten is for written law, okay, we know that Parliament will pass an act. Parlimen akan meluluskan akta, and state assemblies refer to Dewan Undangan Negeri. Dewan Undangan Negeri ni dalam negeri lah, and the Parliament at the federal level. Undang-undang yang diluluskan, okay, di peringkat Parlimen dan juga Dewan Undangan Negeri, kemungkinan, okay, ada possibility di situ, there will be an amendment, ada pindaan, okay, kepada undang-undang akan berlaku, ataupun undang-undang tersebut kemudiannya dihapuskan and replaced by any other act or enactment or ordinance. The law which has been enacted at the federal level or state level, okay, there is possibility for amendment, okay, or for appeal, or to be abolished later. Ada kemungkinan untuk itulah. Okay, seperti kata, di Malaysia pun ada beberapa akta yang pada waktu yang dahulu ada dan kemudiannya dihapuskan. Okay, for example, ISA later on been replaced by OSA, bila mana ISA is the act where someone will be arrested and that person, again, that party will have no right to defend himself. Okay, so that one is considered as against human rights or violation of human rights. Okay, happens there. Okay, bila mana seseorang ditangkap dan kemudiannya tiada hak untuk mempertahankan diri, because we know that in the federal constitution it's contradict, and it's in fact contradict to what has been written, has been stated in the federal constitution, because in the federal constitution it is stated that we have someone who has been arrested, okay, have right to get legal counsel. Means that, okay, when we have right to legal counsel, kita ada hak untuk dipertahankan oleh mereka yang kita panggil dia sebagai legal expert. Dan pindaan undang-undang boleh dibuat, okay, bila mana government merasakan ini sesuai, dan juga kajian telah dibuat dari sudut politik, ekonomi and also social, kesannya kesan kepada perubahan undang-undang itu tadi tidak akan memberi implikasi kepada masyarakat lah. Okay. For example, kalau kata undang-undang berkenaan dengan akta penyakit berjangkit, okay, diluluskan disebabkan oleh pandemik. Okay, so kita katakan dekat sini, okay, undang-undang tersebut digubal untuk, okay, digubal dan dilihat kepada keperluan semasa. Dulu mungkin tak ada, tapi dia adakan sekarang sebabnya kita lihat dengan adanya pandemik dan dalam keadaan bila mana we know that the citizens, civilians ni, orang rakyat ni have to be controlled by law. Sebabnya kalau tak ada regulation or rules dibuat, rakyat akan keluar tak amalkan SOP, bila tak ada punishment yang dikenakan, semua orang tak akan pakai mask, semua orang tak akan scan MySejahtera dan sebagainya. So that's why undang-undang dibuat, okay, melihat kepada keperluan semasa. Ini ada pindaan untuk undang-undang akan berlaku bila mana the government at the federal level or state level think that it is necessary. Sekiranya dirasakan keperluan pada waktu tersebut lah. Okay, so that in fact in our country right now there are several law, okay, still waiting for queue to be amended. Okay, tapi disebabkan oleh pandemik, maka amendment tu agak terkebelakang ataupun tertunda, yang disebabkan oleh keperluan bila mana suatu undang-undang nak diluluskan perlu ada perbahasan dibuat dan dapatkan juga persetujuan dan two-third of members of parliament, 2/3 ahli Dewan Negara dan juga Dewan Rakyat have to agree with that amendment. So bila mana tak boleh bersidang, tak boleh kumpul, walaupun boleh dibuat secara online, tapi ada beberapa undang-undang yang pada peringkat awalnya ditabelkan untuk dibuat pindaan masih lagi dalam proses perbincangan dan perdebatan. For example, right now in Malaysia we have several act For example, on OSHA, Occupational Safety and Health Act 1994. Dah 2 years lah, ambil masa 2 years. But before this, that OSHA 1994 will be combined with Factories and Machineries Act. Factories and Machineries Act akan digabungkan bersama dengan OSHA 1994. Dan perbahasan dibuat hampir 2 tahun sebab masa dia ditabelkan starting from early to 2020. So disebabkan oleh pandemik, ianya tertunda dan 27 Oktober. Okay, today. Okay, today rang undang-undang berkenaan dengan pindaan penggabungan FMA and also OSHA 1994 masih dibincangkan lah pada hari ini untuk menentukan sesuai atau tidak untuk digabungkan kedua-duanya, because when we look at to charge an employer or anyone who involved in case which relate to safety and health, nak decide to have to canvass several law. Okay, tak boleh saja pakai OSHA 1994, Occupational Safety and Health Act 1994, tapi nak kena juga buka Factories and Machineries Act 1967. So that's why, okay, pada awal tahun 2020 dicadangkan untuk penggabungan dua akta tersebut. Okay, supaya dua akta yang berbeza kandungannya, okay, di mana Factories and Machineries Act more on technical part and OSHA 1994 lebih kepada duty of employer, duty of employees, tanggungjawab pekerja, majikan, tanggungjawab kerajaan, tanggungjawab NGO and whatever been mentioned in the OSHA 1994, bahawa tanggungjawab keselamatan dan kesihatan adalah tanggungjawab semua, tak ada dalam Factories and Machineries Act. So itu yang tujuannya digabungkan kedua akta tersebut lah. And there are also several acts. Okay, if you still remember, in 2019 ada perhimpunan, okay, in Malaysia for local students. Okay, in Malaysia there are gathering of people who wearing baju warna purple yang dalam gathering tersebut, okay, mandatnya ialah untuk adanya satu pindaan kepada undang-undang syariah, because we know that undang-undang syariah is too lenient, okay, in Malaysia, di mana undang-undang syariah hanya melibatkan denda, sebatan, okay, dan juga penjara. Tak adalah hukuman berat, hukuman gantung sampai mati sebagaimana dalam civil law. Okay, so therefore the legal expert give an opinion to amend certain provision on punishment under the Islamic law. Okay, tapi sampai sekarang still lagi masih dalam peringkat perbahasan lah. Tak ada lagi perubahan. Okay, it will take time. Okay. Now, clear, okay, from this slide. Okay, we go back to our slide. So written refer to law which has been passed, okay, under the federal or at the state level. Okay. So akta dikeluarkan oleh parlimen. You have to remember that. Take note on that. Okay, bear in your mind, akta hanya diluluskan oleh parlimen and there are two house of law. Ada dua dewan dalam parlimen, iaitu Dewan Rakyat dan juga Dewan Negara. And then untuk state assemblies, Dewan Undangan Negeri yang berada di peringkat negeri hanya layak meluluskan enactment or ordinance. Enactment ordinance sahaja. Akta tidak akan diluluskan oleh Dewan Undangan Negeri. And then subsidiary legislation. Subsidiary legislation is also known as delegated legislation. Okay, if you read certain books or you refer to the write-up on subsidiary legislation in the internet, you can find subsidiary legislation is also known as delegated legislation. I put it in the chat box. Okay. Subsidiary legislation or delegated legislation is the same thing. Subsidiary legislation ni kita kenali dia sebagai undang-undang yang di mana kuasa di peringkat atas, di peringkat federal and also di peringkat state assemblies will give power to the body or organization under them to enact law. Okay, for example, kalau kata di peringkat parlimen, okay, parlimen bagi kuasa kepada ministry, kementerian untuk keluarkan akta, untuk keluarkan rules. Okay, for example, but okay, under the supervision of Parliament. Keluarkan, katakanlah Kementerian Kesihatan bagi opinion untuk diwujudkan satu akta dan datangnya daripada mereka yang relates dengan Kementerian Kesihatan, and then will be debated at the Parliament level. Ataupun Kementerian Kesihatan keluarkan rules or regulation berkenaan dengan peraturan yang berkaitan dengan penyakit berjangkit, for example. Okay, so kuasa tersebut, okay, the power is vested by the federal level, okay, at the federal level to the ministry, ataupun at the state level, okay, state assemblies, Dewan Undangan Negeri give power to the PBT, okay, Majlis Bandaran, untuk keluarkan undang-undang, to pass any law. For example, rules or regulations relates to park a car, okay, untuk kenaan dengan undang-undang berkaitan dengan parkir kereta, nak meletakkan kenderaan. So PBT tetapkan untuk letakkan kenderaan, okay, kita gunakan parking space tersebut. Bila mana kita letakkan kenderaan, kita kena bayar 40 sen, for example, untuk setengah jam. Okay, that one kutipan tersebut dibuat oleh pihak PBT dan ada rules and regulation kita pakai untuk parkir kenderaan tersebut, and that rules or regulation adalah kuasa yang diberikan daripada peringkat negeri kepada Majlis Bandaran. So that's why nama dia delegated legislation, delegate the power, transfer the power, kepada peringkat bawahan. Subsidiary legislation also sometimes known as small legislation, okay, undang-undang kecil. Undang-undang kecil lah, because it's not an act, it's not what we call it, enactment or ordinance, okay, yang diluluskan. Maksudnya PBT tak boleh luluskan enactment or ordinance, it must be at the level of state assemblies, okay, tapi dia boleh sarankan untuk diluluskan suatu undang-undang, tapi bukan mereka yang akan luluskan undang-undang tersebut. So subsidiary legislation adalah undang-undang kecil juga, dimasukkan sebagai undang-undang kecil. So it could be proclamation, okay, or declaration, pengisytiharan. Pengisytiharan also can be a subsidiary legislation. So kalau kata pengisytiharan darurat yang diberikan kuasa kepada Yang di-Pertuan Agong, di mana Yang di-Pertuan Agong dibenarkan untuk mengisytiharkan darurat. Darurat can be anything lah, darurat ni. Darurat boleh juga disebabkan darurat yang melibatkan gencatan senjata, yang di mana kalau kata berlaku peperangan, ataupun darurat di mana kita lihat bahawa kalau darurat yang melibatkan gencatan senjata, askar akan ambil alih kerajaan, askar akan ambil alih tampuk pemerintahan sehinggalah keadaan aman. Tapi dalam keadaan darurat yang diisytiharkan oleh Malaysia that day, ini berkaitan dengan penyakit. So when it involve disease, involve pandemic lah. Okay. So the situation is that untuk preservekan politik semasa supaya tak berlakunya perubahan kepada tampuk pemimpinan pada waktu tersebut dan orang boleh bergerak, tapi orang still boleh bergerak. Kalau darurat biasa gencatan senjata tu orang ramai tak boleh keluar. Darurat ada tempoh dia lah, maksudnya tempoh confinement di mana orang boleh keluar berapa jam saja sehari and then terpaksa berkurung. Tapi ini darurat yang melibatkan penyakit, orang ramai boleh keluar sebagaimana biasa, cuma it just have the main reason, okay, kenapa darurat diisytihar at that time is to preserve the status quo of political situation. Kita nak preservekan, nak maintainkan keadaan politik pada waktu tersebut, tiada berlakunya tampuk pemerintahan dan sebagainya lah, tak ada berlakunya perubahan kepada pimpinan, supaya keadaan tak berlakunya huru-hara lah, okay, dan mengelakkan berlakunya election. Itu tujuan dia. So darurat could be on any reason lah, okay, bergantung kepada kesesuaian. So YDPA boleh isytiharkan darurat tersebut, and then pengisytiharan yang melibatkan, for example, declaration of hari raya, kan, pengisytiharan hari raya also could be subsidiary legislation. Sebab kuasa diberikan. That's why lah kalau you dengar saya dengan ini penyimpan besar, mohon raja-raja okay, mengisytiharkan hari raya bila-bila. So maksudnya diperkenankan oleh majlis raja-raja. Ada orang yang dah bagi approval pada dia untuk buat declaration. So kuasa diberikan. So that's why nama dia delegated legislation, the transfer of the power can be done there. For written law, okay, for written law, we know that at the federal level, and when we discuss about the power of enacting law at the federal level, we must refer to federal constitution. We must refer to federal constitution, Lembagaan Persekutuan, and I think I already mentioned to you, okay, maybe during the earlier discussion of law about the federal constitution. Okay, federal constitution of Malaysia, the Malaysian federal constitution is considered as mother of law, ibu segala perundangan. So any law, okay, any law which is passed, okay, must be referred to federal constitution, must not contradict to the federal constitution. In federal constitution, there is Article 4, Article 4, ataupun if you refer to Malay books, you akan jumpa perkataan Fasal 4. So that one is Article 4. This constitution is the supreme law of the federation, and any law which is inconsistent with this constitution shall be void. Okay, perlembagaan dianggap sebagai undang-undang yang paling agung, supreme. Okay. Supreme law of the federation, and any law, sebarang undang-undang which is inconsistent, which is contradict with this constitution shall be void, shall be null. Okay. Sebarang perundangan yang dikatakan bercanggah dianggap sebagai undang-undang batal. And I think I also did discuss during our discussion on public law, okay, about the constitutional law. Okay, we discussed what is the content of federal constitution, and you also can go through, okay, the content of federal constitution, because I already shared to you in e-learning federal constitution in PDF form. Okay, you boleh baca, boleh go through, very simple. There are lots of things which is considered as big matters, okay, yang melibatkan pembentukan kerajaan dan sebagainya ada dalam federal constitution. So I will not repeat on that. I think I already mentioned, and also I already explained to you about the freedom of speak. Ada tak freedom, a right to remain silent, a right to get legal counsel. Ada tak I discuss dengan you all? Ada tak I mention about that before class? Class? Are you still with me? Mana ni semua orang? Okay,
Yeah, I think yes, Doctor.
ada. Okay, I ada mention about that. Alright.
Yeah.
Risau ni. Petang ni risau ni. Tidur ke? Ya. Kau panggil semua senyap. Okay, sekejap. Ihsan cakap apa? Okay, sekejap. Saya sambungkan charger laptop. Ada melintas tadi soalan daripada Ihsan. Sekejap. Apa yang sana? Ihsan tanya, Doctor, the word inconsistent there has the same meaning with contradict, right? Yes. The word inconsistent, again, the word inconsistent with Article 4, okay, have the same meaning, okay, with the contradict lah. Maksudnya yang bercanggah. Okay. Maksudnya tak sama lah, inconsistent, contradict. Jadi apa saja undang-undang yang diluruskan mestilah in line with federal constitution. If it is contradict, it is inconsistent, not in line with federal constitution, then the law will be declared as null and void, batal. Okay. So for the state constitution, okay, we have a few states under the map of Malaysia. Okay. Kita ada beberapa negeri dan setiap negeri mempunyai undang-undang tersendiri. We have separate constitution. Each state have their own constitution dan ianya tak sama. Okay, so that's why lah kalau kita lihat undang-undang tubuh setiap negeri ni, normally sometimes ada setengah negeri dia tak panggil state constitution as perlembagaan negeri. Maybe ada yang panggilnya sebagai undang-undang tubuh. Maksudnya refer to constitution lah. Okay, dinamakan sebagai undang-undang tubuh. So the state constitution is different from one state to another state. Okay, that's why kalau dilihat dalam dalam sesebuah negeri, okay, di mana ada sultan yang berkahwin dengan orang biasa dan that person, okay, walaupun berkahwin dengan orang biasa, dan kemudiannya dinamakan orang kebanyakan tersebut sebagai pemasyuri. Okay, tapi ada juga negeri yang menetapkan bahawa pemaisuri ataupun sultanah, okay, wife kepada sultan, mestilah someone who come from blood royal family lah. Maksudnya ada kaitan dengan darah diraja, tak boleh daripada orang kebanyakan. Tapi if you can see that, for example, situation in Perak, okay, so kalau dulu almarhum Sultan Azlan Shah, okay, married to Bainun. Bainun is only a teacher, tapi diangkat, okay, dan ditabalkan menjadi pemaisuri. So ada setengah negeri menerima situasi berikut sebagai satu perkara biasa. Tapi ada juga negeri yang di mana dalam perlembagaan tubuh ataupun state constitution menetapkan bahawa sultan hanya boleh mengahwini perempuan yang mempunyai darah diraja sahaja. Maksudnya daripada kerabat sahaja, tak boleh orang kebanyakan. Dan kalau kata kahwin dengan orang kebanyakan, that person will not be declared as pemaisuri ataupun sultanah lah. Okay. Ini berdasarkan state constitution. So state constitution ni ada perbezaan lah. Okay, merujuk kepada undang-undang di negeri tersebut. Jadi tak sama. Dan jurisdiction of the state, okay, jurisdiction of the state, what has been stated in the federal constitution, okay, dalam senarai kedua dan juga senarai ketiga, itu yang telah ditetapkan oleh federal constitution lah. Okay, bidang kuasa kerajaan negeri, for example, jurisdiction of state relates to Islamic matters, okay, because we know that head or leader of the Islamic law, okay, referring to a state, dia bergantung kepada sama ada negeri tersebut ada sultan ataupun tidak. Jadi kalau kata negeri yang punya sultan, maka sultan tersebut dianggap sebagai head or leader of the Islamic matters lah. Jadi kalau kata ada sultan, maka sultan akan jadi ketua agama kepada negeri tersebut. Tapi kalau negeri yang tiada sultan, maka YDPA yang di-Pertuan Agong will act as head or leader of the Islamic matters. So jurisdiction of the state berkenaan dengan perkara yang melibatkan undang-undang Islam ni memang dah termaktub dalam perlembagaan persekutuan. Okay, has been mentioned clearly in the federal constitution about the Islamic matters, okay, must be handled by the state. Nanti kita akan bincangkan about the jurisdiction of the state, okay, at the end of our discussion in Malaysian legal system. So as per I mentioned to you before that, okay, undang-undang, okay, we have acts, enactment acts ni paling atas lah. Okay, acts ni yang paling tinggi. Okay, Akta merupakan undang-undang yang paling utama, and it's been followed by enactments or ordinance, and then we have rules. Kita ada regulation, rules, regulation, policy. Okay. So policy tu dasar lah. Jadi benda yang paling maksudnya makin turun dia punya tingkatan undang-undang tu. So acts will be passed by parliament, enactments and also the ordinance will be passed at the state level, okay, at the state assembly, Dewan Undangan Negeri. And subsidiary legislation, tadi kita dah bincangkan. Okay, subsidiary legislation is also known as delegated legislation. Also known as delegated legislation. It's a law made by person or bodies under powers conferred on them by acts or parliament of state assemblies. Jadi kuasa diberikan sama ada oleh parlimen ataupun Dewan Undangan Negeri kepada badan-badan tertentu, pada ministry, kepada organisasi untuk meluluskan sebarang undang-undang. And then when I discuss about yang di-Pertuan Agong tadi, okay, for example, one of the power wasted at the hand of yang di-Pertuan Agong ialah untuk mengisytiharkan darurat, for example. Okay, so kita nampak that day our YDPA use that power, okay, dan dia mengisytiharkan darurat, dan darurat could be several darurat lah. Kita jangan fikirkan bahawa darurat ini melibatkan hanya kejahatan senjata bila berlakunya peperangan, kekacauan dalam masyarakat saja, tapi it also can be referred to pandemic. So okay, rules and regulations are also by law. Okay, so anything that you want to ask, okay, about the written law, undang-undang bertulis, before we go to the unwritten law. Okay, lepas ni kita akan bincangkan about the English law, Islamic law, judicial decision, custom. Okay, kalau tak, kita ambil masa sekejap berehat lah. And then sambil tu fikir ada benda nak tanya before we go the unwritten law. Can we take 10 minutes break? Class? Boleh? Okay. Okay, in the meantime, for those who joined late, okay, please sign in your attendance via Google Form in e-learning. Okay, we take 10 minutes break. We continue at 3:05, 3:37.